The number you have reached, 911, has been changed to a non-published number.
Now we get to substantive matters, and we start out with violent crimes, abduction, and the incidental detention doctrine. Now, everybody who knows this, the incidental detention doctrine is basically if someone is restrained as part of an offense that they would have to be restrained as part of, or moved as part of an offense that they would have to be moved as part of, then they can't be convicted of abduction. Now, if the movement, the asportation of the person, or the detention of the person is not incidental to the crime being committed, then abduction can be charged. Whether an abduction is incidental to another crime is a matter of law. That's problematic to me because it's a jury's decision as to whether or not someone is guilty of this or that offense, and basically saying that it's a matter of law whether the abduction is incidental to another offense is deciding a factual issue as a matter of law. I think that's problematic. There are 4 factors to consider in determining whether the detention or asportation is incidental or an abduction. A. 1. The duration of the detention or asportation. 2. Whether the detention or asportation occurred during the commission of a separate offense. 3. Whether the detention or asportation which occurred is inherent in the separate offense. And 4. Whether the asportation or detention created a significant danger to the victim independent of that for the other offense. A detention or asportation that is merely useful, not inherent, just merely useful to a crime, is not intrinsic, and therefore the defendant can be convicted of abduction. In this case, as I call it, the defendant lied to a woman to get her to come into his house, and lied to her to get her to go into his bedroom, and thereafter he attempted to rape her. Okay, so the finding of the court basically is the lie, the deception, which got the person to move from point A to point B, and after which he engaged in the crime, that the actual asportation, the actual abduction occurred before he engaged in the crime. Therefore, there could be an abduction. Okay, so then we get sex crimes. Section 18.2-374.1:1, possession of child pornography. And somebody here, I got to give some credit to the defense attorney. He got creative trying to argue here. And the statute under subsection A requires that if the internet cache, which is where temporary pictures are stored by your browser or whatever else you're getting on the internet with, if it has 3 or more child pornography pictures, then the person can be charged. And the defendant tried to say, well, that means you can only give my client 1 charge for every 3 pictures. And the court says, no, that's not the way it works. It's a threshold requirement. Once there's 3, they can charge you with every your defendant with every picture in there. Good try, but no. Okay, 18.2-374.3, soliciting sex with an under 15-year-old via a communication system. This is Groffmuller against Commonwealth from the Court of Appeals. The statute imposes a mandatory 5-year sentence for any person who knows or has reason to believe there's a child less than 15 years of age that he's trying to get a hold of, right? And communicating to try to get a hold of. If the offender believes the person he is contacting is a child, then the person is a child for the purpose of the statutes, even though it's a policewoman. So while the statute says child, the Court of Appeals is hereby expanding child to mean both child and the policewoman or policeman who is playing the role of a child. and therefore the mandatory minimum 5-year sentence must be applied. I've got some issues with that. I mean, it says child pretty clearly. Now, there's things they could have broke this down a little bit differently. And this is one of the first cases I read, but I'm trying to remember. They just basically say no. The policewoman's a child for this case. This was a guy who was trying to solicit a girl under 15, to have sex with him. It actually turns out it's a policewoman. They could say here that he knows is a child, or has reason to believe is a child. Has reason to believe is a child doesn't mean it has to be a child, but that's not the way they went. So, while I think they may have reached the right reason, I'm not sure their analysis is correct. Moving on to drug crimes. 18.2-255 AII. Causing a person under 18 to assist in the distribution of marijuana. This is Kelso against Commonwealth from Court of Appeals. They distinguish this from other cases. Unlike other possession or other distribution cases, which happen at the location they happen and are done, this is a continuing offense. And the activities of the seller or the person putting the juvenile in play, and the juvenile can make jurisdiction in whichever county the two are in. So if the person gives the juvenile the marijuana in Botetourt County, and the juvenile goes to Henrico County to sell it, well, then both of those jurisdictions have jurisdiction. Both those counties have jurisdiction. Theft and property crimes. This is grand larceny, 18.2-95. Well, grand larceny is common law, actually. Williams against Commonwealth. If the defendant was a passenger in a stolen vehicle, which it's not enough to convict him, just the fact that he was a passenger in a stolen vehicle. However, if he's a passenger in a stolen vehicle and he told somebody it was stolen, and the vehicle stopped to pick up his friend, and it was not a friend to the person driving, and the car stopped so that they could talk to the passenger's cousin, and the defendant was heard saying when he got out of the car with the driver, "Oh, so far today we haven't gotten arrested." That's all enough to show that the passenger had joint dominion over the vehicle, and therefore he is as responsible under the recent possession doctrine as anyone else, as the driver is. So, because he has unexplained recent possession of stolen item, you can infer his guilt. Okay, weapons crimes. Possession of a firearm, and this falls under various statutes. The two statutes which played out in this one were 18.2-308.4, which is possession with a drug, and 18.2-308.2, which is just possession as a felon. Basic things that you've heard in a lot of cases before, or read in a lot of cases before. You can constructively possess a firearm. You can jointly possess a firearm if it's in a vehicle. They do go on specifically in 18.2-308.4b. The language says it has to the firearm must be on or about his person, and the defense counsel tried to argue that meant it had to be actual possession, and the Court of Appeals rejects that and says no, and pretty clear, on or about. About would mean close to, so it can be constructive possession. Motor vehicles. Ricks against Commonwealth. This is a DUI case from the Court of Appeals in which we have our genius of the month. Ricks is a passenger in a car, and they get pulled over. While the state trooper is walking up to the car, Ricks, who already has several prior convictions for driving under the influence and refusing, I think, tests and all sorts of stuff, switches with the driver while she's intoxicated. Ricks is intoxicated. So they switch places. The state trooper gets to the car. The key's still in ignition. The engine is still running, which means it's operating, and Ricks is sitting in the driver's seat. The Court of Appeal says, well, that places her in dominion of the vehicle, dominion and control of the vehicle, and therefore she's operating it, and operating it under Virginia law means you're guilty of DUI, and Ricks, because she changed places with the previous driver, gets herself a DUI.